Crimes against property, theft, found in Articles 308 to 311 of the Revised Penal Code. Who are liable for theft? Theft is the taking of personal property belonging to another with intent to gain without the consent of the owner and without the use of violence against or intimidation of persons or force upon things. The absence of violence, intimidation, and force upon things is what distinguishes theft from robbery. What are the elements of theft? 1. The taking of personal property. 2. The said property belongs to another. 3. The taking be done with intent to gain. 4. The taking be done without the consent of the owner. And 5. The taking be accomplished without the use of violence against or intimidation of persons or force upon things. Other persons who are liable for theft. Any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or objects of the damage caused by him. And any person who shall enter an enclosed estate or a field where trespass is forbidden or which belongs to another, and without the consent of its owner shall hunt or fish upon the same, or shall gather fruits, cereals, or other forest or farm products. What is the finder-in-law doctrine? Theft by failure to deliver lost property does not require that the offender be the actual physical finder. A person who, knowing that property was lost by its owner, places himself in the same position as if he were the actual finder, by appropriating the property and convincing others to do likewise, is a finder-in-law and is equally liable for theft. Take note that theft is consummated upon unlawful taking. There is no frustrated stage. Theft has no frustrated stage. It can only be in the attempted or consummated stage. The reason is doctrinal. Under Article 308, theft is consummated the moment there is unlawful taking of personal property of another with intent to gain, and without the owner's consent. Once unlawful taking is complete, the felony is consummated. Ability or inability to dispose of the thing is immaterial. The conceptual frustrated stage, performance of all acts of execution that would produce the felony, but for a cause independent of the offender's will, never arises in theft. In contrast, robbery has all the stages of execution. Attempted, frustrated, and consummated stages are all possible. What about snatching? Snatching is the taking by sudden motion or grasp. Is this considered violence already, that it will amount to robbery? Now, in Del Rosario versus People, it is held that it is theft, not robbery, when there is no violence or intimidation that accompanies the act of taking. The element of suddenness cannot be readily equated with the employment of violence or physical force. This distinction matters in jeepney snatching and street grab fact patterns. Hence, if the snatching is by sudden grasp without violence or intimidation, it is theft. The connotation of grab is suddenness, not the use of physical force. Now, the question is, what is the penalty for theft? It is found in Article 309. So, as we all know, the penalty for theft is based on the value of the property stolen. In 2017, the RA number 10951 updated the value brackets of the penalties. And as we have learned, the courts apply the law in force at the time of the commission of the offense. Now, if the offense is committed after the amendment, then the new bracket of amounts will control. However, in one of the bar chair's spent cases, the petitioner was convicted of theft and sentenced under the old brackets. The Supreme Court applied RA 10951 brackets retroactively were favorable to the accused, as this is a basic principle in criminal law. With the value of property stolen straddles a bracket and the offense was committed in the transition period, ask whether RA 10951 lowers the penalty. If yes, apply the new brackets to the accused benefits.